Good afternoon, Jasmine.
Good afternoon. How are you?
I'm good. And yourself?
Hmm.
Said I'm good. And yourself?
I'm hanging in.
That's me, Katrina.
How are you?
I'm good. I'm good. And yourself?
Hmm.
Said I'm good. And yourself?
I'm hanging in.
That's
Good morning or good afternoon. We're used to saying good morning. All right, we'll get started, everyone. Sit. We'll have a couple private attorneys on. I see one. Yes. And I can't read Miss Jackson, the rest of the name tag. Who's your client?
Your Honor, good afternoon. My client is Jamari Welcome.
Welcome. Let's see. Okay, I see him. 20. And did I see another private counsel or no? I think you may be the only one.
No, there is another one for,
There is another one. Okay.
But he was sent the link to get in. I don't know whether or
Oh,
not he's in yet. But he's
okay.
on position number 10.
10. Okay. Attorney Jackson, we'll try to get you out in a second. Let's
Yes, Your Honor.
see. The order sometimes is obviously dictated by the jail.
And by the way, Your Honor, the reset date for the SAP calendar for everyone is September the 3rd.
September the 3rd. All right, ladies and gentlemen, we'll go ahead and get started. Good afternoon. We're going to begin our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's Office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. You've already heard that the state all-purpose reset date is September the 3rd. I want to begin by advising everyone that this whole entire proceeding is being recorded and live streamed on YouTube. Govern yourselves accordingly. I also want to remind the defendants on this calendar that you do have certain constitutional rights. The first being that you have a right to counsel. At this point, you should know who your attorneys are. Listen to them. Also want to remind the defendants that you do have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. The state is here and they're listening. So once again, follow the direction of your attorneys. All right, who do we have first, deputies?
Position 1, Allen.
Okay. 24 CR 005833H, Jasmine Allen, charged with 2 counts of simple battery family violence, pretrial.
First arrest. No. Third arrest. I had the other Allen on here.
Okay.
2017 probation, 2016 simple battery DV NOLO. That's it.
Stace?
Good afternoon, Your Honor. This incident happened on August 19th of this year. Officers were dispatched to 3041 Landrum Drive Southwest, Building 12, Unit F, like Frank, regarding a dispute between the defendant and her live-in boyfriend. His name is Richard Corbett. He told police that they were arguing and it got physical when he was taking out the trash. She slammed the door on him while his feet were still in the threshold, hurting his foot. He was angry. He then reached inside the door to move the defendant from behind the door and mistakenly hit her in the face. An hour after this incident, the defendant approached the victim to talk about what had happened. He was not ready to talk yet, and that upset her, and she pulled his hair and began slapping him. The officers spoke to the defendant as well, and they determined that the defendant was the primary aggressor in this incident. We have not been in touch with Mr. Corbett today. And this defendant does have a previous conviction for simple battery from 2016. The state's position is that her risk of reoffense is high now that this is her second offense. The state is requesting a $1,500 surety bond on each count, Your Honor. No further contact with this victim. Stay away from the incident location. No weapons, drugs, or alcohol while out on bond. And if the court can sound for Mr. Corbett, thank you.
All right, Mr. Richard Corbett. Mr. Corbett. All right, PD Cook, is this your case?
Yes, Your Honor. My client has no objection to a stay away or a no further contact. She is 25 years old and has lived in this area her whole life. She's not currently working. A surety bond would be difficult to make. So we would be seeking, I didn't hear the full history there, but we would be seeking a signature bond at whatever level the court deems appropriate.
Said she's unemployed. How old is she again?
She's 25.
25.
Yes.
From Georgia.
Yes.
Do you have any other family support?
Yes, her mother is here in town, and that's the only person I know that we discussed.
All right, I will give her a $3,000 signature bond through pretrial, $1,500 on each charge. I'm going to order her to stay away from 3041 Landrum Drive, Building F. I'm assuming she does not reside there.
No, she does not.
No further contact with Richard Corbett. Let's let them have some cooling down here. I think it's been less than 24 hours. No further contact. I'm going to order her to take 2 weeks of anger awareness courses through pretrial.
What's your level?
Level 1. And no drugs, alcohol, weapons, or guns while on bond. No unprescribed medication or unprescribed drugs. And I think that's it. Anything else, counsel?
No, Your Honor.
All right. Next.
Position number 16, Mr. Welcome.
Okay.
Good morning, Your Honor. I mean, good afternoon.
All right.
Once you said it, now I keep saying
I
it.
know now. I started that. All right. 24 CR 005843J. Mr. Jamari Welcome is charged with 1 count of terroristic threats and acts. Pretrial.
I got first arrest.
Okay. State.
That's my case, Your Honor. Thank you.
Huh?
That is also my information that there are no prior arrests or history. This is an incident that actually occurred in May the 4th of 2024. The victim in this case, her name is Khadijah Baldwin. I believe she's joined us on the Zoom. She went into the headquarters in Sandy Springs at about 6:30 p.m. on the 4th of May and reported that earlier that same day, or actually it was continuing, she was receiving death threats from her ex-boyfriend. She described him as her ex-boyfriend and said they share a child. While on the scene with police, she was actively receiving text messages from the defendant, and so the officer who took her report was able to view those. The threats included telling the victim he was going to have his mom and his sister come and assault her. And at one point, he stated in the text message verbatim, "When I stab you in the face, it's going to be worth it." The victim reported to police there at the police station that there had been prior incidences over the last year and that it had become physical multiple times. She also reported that she hadn't called the police immediately because she was afraid and she didn't want it to become physical again. a police report was generated and she was given a number, and investigator for domestic violence, Investigator Delaney in Sandy Springs, followed up with her. Unfortunately, at that point, she decided she was not interested in being cooperative and refused to speak with the investigator other than to minimize her prior report and refused to provide the evidence that police had seen when she made the report. We have spoken to the victim, Your Honor. She reports that she and the defendant are not in a relationship, but they do share a child. And she reported that she only wanted to show the text messages to police initially because she had a question. And she denied that there had been any physical altercations in the past, which is a direct contradiction to what she reported at the police station. So based on the information provided, Your Honor, we would argue that the Ayala factors show that there's a risk to intimidate, and we would require or ask for a $2,000 surety bond here, Your Honor. Have no contact with the victim, Mrs. Baldwin, and stay away from wherever she may reside right now, and no drugs, alcohol, or weapons while on bond. Thank you.
All right.
And obviously, if you want to sound for her, so you can hear from her yourself, Your Honor.
Yes, Khadijah Baldwin. Do you wish to address the court today? Yes or no?
No, I stated everything when they called me earlier.
Okay. All right, we'll move forward. Attorney Jackson.
Yes, Your Honor. Using the Ayala factors, my client is a excellent candidate for a bond. He does not have a previous record. He has ties to the community. There's no risk of him intimidating witnesses. Ms. Baldwin indicated to the officers back in May that she didn't want to proceed, that she wasn't afraid. It's my understanding that she also told that to the state. And I did have a conversation with her where I did inform her that I represented Mr. Welcome. And she also informed me and sent me something in writing stating that she wasn't afraid and she did not want to proceed. And Your Honor, if you even look at the narrative that's part of the warrant, it does state at the end that she didn't want to proceed, that she just wanted to ask a question. So, Your Honor, I know this is first appearance, but I would also like to make a probable cause argument that I don't think that the state has enough probable cause even to continue with this charge. Ms. Welcome did show text messages. Not Ms. Welcome. Ms. Baldwin did show the officer text messages, but this was a mutual conversation. And with OCGA 1611-37, which is the statute for terroristic threats, it has to be with the purpose of terrorizing another person, which would make it a misdemeanor. Your Honor, I submit to the court that this was an argument. Ms. Baldwin will also, if you want to hear from her, but she did state to me that this was an argument. They both had made statements to each other. She got upset, she went, and then when cooler heads prevailed, she even told the officer that it was an argument and she didn't want to proceed. So I would ask for a dismissal due to no probable cause. In the alternative, Your Honor, we would ask for a $1,500 surety bond if Your Honor determines that there is probable cause. But I would ask the court to do a probable cause analysis and dismiss this case.
Your Honor, if I might have a moment to respond.
Mm-hmm. Go ahead.
Probable cause for terroristic threats on a misdemeanor level doesn't fail because a victim says she doesn't want to pursue charges or because she now says that this was an argument. A terroristic threat can be made in any context. The probable cause argument is frankly a waste of time, but obviously we've got a victim here who's recanting and minimizing. She made contradictory statements to us, to officers when they tried to investigate, and you can talk to her yourself, Your Honor. Thank you.
Your Honor, if I could be heard, yes, the fact that she recanted, I know the state can't pick up the charges, so I do, that wasn't my argument. I was saying as far as terrorizing another person, Mr. Welcome was not trying to terrorize her. They were having a mutual argument. We may agree that the things that were said back and forth, but it wasn't to terrorize her. It was a mutual conversation where they both had made threats to each other, which I'm sure Ms. Baldwin I know she said she didn't want to make any statements, but that's what she even told the officers at the time. And an escalated argument is not terroristic threats. Okay, it's not him trying to intimidate her. It's a back and forth argument. So I would submit to the court, it fails the element of that the purpose was for Mr. Welcome to terrorize Ms. Baldwin. That's my argument, not the fact that she recanted.
Okay. And so even with that, we've passed the probable cause stage at this point. You can argue that with other motions that will be filed after he's released on bond and as the case progresses. But today I'm here to determine bond. And
Yes,
since this is his first arrest, and he doesn't obviously meet any of the factors under the YALA standards that would cause me concern right now, except that hopefully they're done with whatever was going on between them, since it is now August and there hasn't obviously, I hope, not been any subsequent interaction.
And Your Honor, sorry to interrupt. It's my understanding in speaking to, and they do have a child together. We would ask for no violent contact.
Do they live together?
They don't live together, but they do have a child together.
Yeah, I'm concerned. We want to make sure the victim is safe and that the child is safe as well. And I don't know if they're doing visitation, have they been married? Is the child legitimated?
Well, the child is currently with Mr. Welcome. So, with his parents. So the child is currently with Mr. Welcome. They do back and forth as far as childcare. So they are both active parents. So I would ask for no violent contact because it's going to be difficult, because it's my understanding that Ms. Baldwin relies on him and his family for childcare. It sounds like, because the child is relatively young, it sounds like they have a schedule where they both keep the child for extended periods of time.
Okay. Well, I will grant the $1,500 signature bond. I will grant that signature bond through the jail. And I am going to ask that Mr. Welcome take a 2-week anger awareness or anger management course. I guess I will go ahead and order no further violent contact with the victim if that's what she wants. State, did you have any evidence that she wanted anything different?
I mean, Your Honor, what you're experiencing right now is a classic case of domestic violence. This young woman has minimized and recanted her position. You have just heard that she's dependent on the defendant for care of her child. They are not married. I don't believe the child has been legitimated. I haven't heard anything related to that. The facts of this initial incident are that she reported to the police that the defendant was threatening to have his sister and his mom come assault her. And just for your information, terroristic threats isn't about the intention of the defendant. It's about the perception of the victim. These are serious cases. And you've got a woman who is vulnerable, who's got a small child, who went and made outcry and is now in a different position and is relying on the people who were threatening her when this happened for child care and support. So we would continue to say that there's a safety issue, there's a risk to reoffend as far as the IALA factors are concerned, and there's a risk to intimidate because it's our position that that's already happened, Your Honor. So we would join with any anger management. And until there's an order of the court around custody and visitation, we would ask that the court make it clear the rights to access to this child sit and belong with the victim in this case, not the defendant.
Your Honor, Ms. Baldwin is on the line, and I know she didn't want to make a statement, but if you want to ask her directly if she would like to have contact, she has indicated it's not like she's recanting now. This incident happened 3 months ago. When they called her back when they were filing the warrant, it's not like she's saying, oh, these horrible things happened. She acknowledged that it was just an argument at the time and she was upset. And I think that there are real victims out there. There is such thing as a battered woman syndrome, but that's not what we're having today. And I know Ms. Baldwin is here, but I do have to be candid. I represent Mr. Welcome. There's also women who get upset, go to the police.
Your Honor, we're going to object at this point.
Yeah.
Ms. Baldwin has made her position. She spoke to us. We've made our arguments.
Ms. Baldwin,
Yes.
do you feel comfortable answering 2 questions for me?
Yes.
You under oath? I'm going to put you
Wait,
under
I'm-
oath. I need you to turn on your camera.
Okay.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Mr. Jamari Welcome?
No.
Do you want to have any further contact with Mr. Welcome?
Can you repeat the second question?
Do you want to have any future contact with Mr. Welcome?
Yes.
Are you intimidated by Mr. Welcome?
No.
Has your child been legitimated by Mr. Welcome?
No.
How old is your child?
2.
And you rely on his family and parents for child care, is that correct?
Yes. Him and them. Both of them, yeah.
Okay. And since this incident, they've been providing that child care?
Yeah. Regularly or whenever I ask. Yes.
And Mr. Welcome has, Mr. Welcome has as well?
Yes.
Okay. And you all do not live together?
No.
Okay. Any cross-examination by the state?
No, Your Honor, nothing further.
All right. All right. I will go ahead and give my ruling. You can mute yourself, Ms. Baldwin. I'm going to order a $1,500 signature bond through the jail. I'm going to order that 2-week anger management course. I'm going to order no further violent contact with the victim and the minor child. No drugs, unprescribed drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else, counsel?
No, I just have a question. Where does he get the information about the 2-week class? Is that going to be provided before he's released?
No, because I'm not bringing him through pre-trial, because they would have provided if I put the bond through them, unless it's what you want me to do, then he can take it through them for free. Otherwise, you have to find it and pay for it himself.
Okay, perfect. Okay, I just wanted to let him know. So we just have to find a private anger management. He has to do that within 2 weeks.
No, do it for 2 weeks.
Oh, for 2. Okay.
Yeah, for 2 weeks.
Oh, for the 2-week course. Okay.
Correct.
Okay.
Okay. All right. Thank you.
Thank you, Your Honor. That does conclude my business. Might be excused.
Yes, you may. Thank you.
Thank you.
Section 14, Ms. Underwood.
This is 24 CR 005842F. Zane Underwood Linton, charged at 1 count of battery family violence, pretrial.
I got first arrest.
Okay. State.
Thank you, Your Honor. That is my case.
Mhm.
One moment. This is an incident that occurred on the 2nd of June. So this is a delayed arrest. Warrants were obtained 3 days later on the 5th of June. Police were called to the location at 2804 Fairburn Road Southwest at about 5:20 in the afternoon. The victim, the sister of this defendant, her name is Zamira Underwood Linton, first name spelled as Zmeria. She reported that her sister and a cousin named Fatima Goodman had come to the location to pick up her younger brother. The victim reported that their mother had died recently, and their younger brother, had been staying with her. His date of birth shows he was born in 2010. so a minor. The defendant, Mrs. Zane, and the cousin came to the location and demanded the custody of the child. She denied that access. They tried to push their way into the door, and told them he wasn't going to join them. The victim tried to close the door. She was thwarted because there were two of them. They barged into the residence and assaulted her. She was repeatedly struck in her face and head. At one point, this altercation went out into the front yard. There was a witness on scene. Mrs. Michaela Miles reported to police that she saw the altercation, and at one point, bricks in the front yard were used to strike the victim, Mrs. Zamaria. When police arrived on the scene, the defendants had fled and they had taken the juvenile. The victim reported that there's been no official legal decision about whose custody this little brother has been chosen to go into. She was transported to Grady for treatment. The scene, including the bricks in the front yard, as well as the witness on scene, corroborated the victim's statements. We've not been in touch with the victim this morning, Your Honor. However, I would say that were that to happen, and we do corroborate information about the use of a brick or any injuries, this could be upgraded to a felony level assault. But at this point, you've got a battery, family violence between sisters who used to live in the same household in front of a witness. We'd be asking for a $2,000 signature bond through pretrial, Your Honor, level 2. Stay away from the location at 2804 Fairburn Road and have absolutely no contact with the victim, Zamaria, Zmeria, Underwood Linton, and her brother, the juvenile. His name is James Linton, Lenton.
JL.
James. Yes, Your Honor. Until such further order of a superior court addressing custody of that child. And no drugs, alcohol, or weapons while on bond. Thank you.
So right now, do we know where the child resides or where the child is?
I'm unclear about that. Maybe defense counsel's got some info.
I'm mystified. I was going to ask myself, when can DFACS get involved and figure this out? Because this is tragic within the family. I'm sorry their mother died, but a 14-year-old we know is old enough to choose custody when there's a divorce going on, but this is not that situation. 14-year-old is vulnerable and not completely mature, and DFACS needs to be involved.
All right. Do we have the victim on the line at all? Zamira Underwood Linton at all? Don't think so. All right, go ahead, Mr. McLean. Maybe you can ask your client.
Well, Your Honor, for the first arrest here, I would basically address bond at this time.
Okay.
We would agree a signature bond would be appropriate with no contact with the alleged victim and stay away from the location. And I could get into a breakout session and try to find out some more information.
How old is your client?
My client was born, 24.
Okay. And what about her background? Does she work? Is she in school or what?
Your Honor, she works at a healthcare place. It's an agency that sends caregivers into homes. They go in for several weeks or months at a time, usually on a typical assignment. So it's a home health care. She's been doing that for a while. I don't think I've got down how many months she's been doing that. The address is correct on her 3 card, also known as the booking sheet. She does have, besides the cousin mentioned in the police report, she has other cousins. It's a large family. I think the family influence could be for everybody to calm down.
How do we know how long the mother's been deceased? Is this
I-
something very recent? Can she answer that question?
I don't know. Miss Underwood Linton, when did your mom die?
May 30th, 2022.
2 years ago?
2 years ago.
And so my understanding is that this minor child, this 4-year-old, initials JUL, has been residing with the defendant.
He's 14, Your Honor.
Huh?
14, not 4.
Oh, 14. I heard
Right.
that incorrectly. I'm sorry. And he's been residing with whom? With the victim, and the defendant came to take the child from the victim. Is that what I'm understanding?
That's my understanding of the reading of the documents in front of me, Your Honor. But
That's
again, we haven't been able to talk to the victim.
That's definitely what the document says. I agree.
Okay. All right, I'm going to order a $2,000 signature bond through pretrial. And that will be level 2. I'm going to ask that she take 1-week anger management course. I'm going to, and I'm assuming Miss Underwood Linton does not live at the 2804 Fairburn Road.
Correct, Your Honor. She lives at the address shown on the booking sheet.
Okay, so stay away from that location right now. We want to make sure, although this was in June, the mom died some years ago, there still may be some undergirdings going on here. So we want to make sure this is all calming down now, and hopefully they can get together and work this out somehow. So I'm going to order to stay away from that location right now. And they're sisters. But I don't know if they're getting along, not getting along. It's been 2 years, but I know grief and issues can happen. I'm trying to debate whether I'm going to have them to have no further contact with each other or no further violent contact, because it looks like, or maybe they both have to share in raising this minor child.
Your Honor, the state would request no contact at this point until a modification can be requested with more information and input from the victim.
Okay. All right, let's do no further contact. And then if you all need to apply for an amendment, Mr. McLean, you all can do that.
I'll make a note. I think that's appropriate.
Okay. All right, we'll do that. And no drugs, unprescribed medication, alcohol, weapons, or guns while on bond. And that should do it.
Position 4, glass.
Okay. This is 24 CR 0058337G, Dover Glass, charge at 1 count of criminal trespass. Retrial.
62. 2024 probation. On probation for shoplifting out of Superior Court. Well, he's on probation for 2 shopliftings in Superior Court. 1 entering auto with the intent to commit a felony. What else? Several probation violations, shoplifting conviction, 2017, 2016 shoplifting conviction, 2016 trespass conviction. That's all.
All right. State.
Your Honor, this incident happened on August 18th of this year at the Kroger at 590 Cascade Avenue. Police responded to a trespass call. Mr. Glass had come to the Kroger on this incident date on the 18th after having received a criminal trespass warning 3 days earlier on August 12th. He does have a prior conviction for criminal trespass. He's also, as pretrial mentioned, a recidivist shoplifter. And this year, Your Honor, he pled to entering auto for 4 vehicles last year, and he's violated that probation. He's also serving a 13-year sentence on probation for his shoplifting from 2017. The state would request a $1,000 good bond. Your Honor, stay away from the Kroger. No weapons, drugs, or alcohol while out on bond. Thank you.
All right, Mr. Cook.
Your Honor, given the background as stated, we would not have any objection to the state's request. I would say that he is homeless, has no job, so he doesn't really have many funds to deal with a surety, but just hearing the background, we would have no objection.
All right, I'll order the $1,000 surety bond. Maybe you can have your behavioral health to do an evaluation or help him with housing once you make bond. Stay away from the Kroger on Cascade Road. Please stay away, stay away. And no drugs, unprescribed medication, alcohol, weapons, or guns while on bond. That's it.
What was that amount?
1,000 surety.
Thank you.
Position number 11.
This is 24 CR 005835C. Katrina Scriven, charged with 1 count of battery, family violence, pretrial.
Yeah, first.
Okay.
Thank you, Your Honor. This is an incident that happened on the 10th of July, so this is a delayed arrest. Warrants were obtained on the 22nd of July. Between 11 p.m. and 2 a.m., police respond to 2247 Springdale Road, Southwest, where they met with the victim. Let me make sure I have his name correctly. One moment. He reported that he was staying in his brother's house for a period of time. He and his living girlfriend, Christine Gamez, had been having some issues recently. And her daughter, the defendant in front of you, and his girlfriend, Christine Gamez, so Mrs. Katrina Scriven, date of birth 12/2/01, and her mom, the current girlfriend of our victim, showed up at his brother's house where he was staying and tried to forcefully enter the back door. He tried to prevent them from coming inside, and while doing so, the young woman in front of you tased him on the arm with a taser or a stun gun of some kind. He fell back and received an injury on his elbow, which is the basis for the battery, Your Honor. He refused medical attention, and the defendants fled from the scene. The victim's name is Bruce Johnson. So his girlfriend, Christine Gamez, Gamez, is the mother of the defendant. We've been in contact with him today, Your Honor. He said that he is currently staying at his brother's house. He confirmed the information in the warrant that they've had altercations in the past, he and his maybe would-be stepdaughter, and that police had been called by neighbors in the past. He used to reside with her mother. He's requesting no contact and to stay away. We'll be joining that. We'd ask for a $2,000 SOB through pretrial level 1. Absolutely no contact with Mr. Bruce Johnson, and to stay away from 2247 Springdale Road, Southwest. Thank you.
All right. P.D. McLean.
Your Honor, she works at a restaurant on South Cobb Drive. She's been working there for 2 years. She is in school to become a dental assistant, and that's taking up an additional 32 hours per week of her time. She would be in disagreement with these facts alleged. I believe this may be her first arrest. And we would ask for a signature, and we completely agree with the no context.
All right. Or the $2,000 signature bond through pretrial level 1. I'm gonna order her to take a 1 week anger awareness course. I'm going to order stay away from that 2277 Springdale Road Southwest. I'm gonna order no further contact with the victims. And I believe it's what Bruce Johnson and Christine something, or who are the victims?
It's
Just
just
Bruce.
Mr. Johnson, her mother, the defendant's mother is the live-in girlfriend or previous live-in girlfriend to the victim. So she'd be being ordered to have no contact with her mom, and that doesn't make sense. And arguably her mom's a co-defendant. So
Okay. No further contact with Mr. Johnson. And stay away. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond.
HCDC, go ahead.
Thank you. Good afternoon, Judge. This is going to be number 7, Ms. Pierce.
This is 24 CR 005840Y. Armani Pierce, charged with 1 count of criminal trespass and damage to property, pretrial.
First.
Okay. State.
Your Honor, this incident happened last year, February 24th of 2023 at 1040 Meadow Glen Parkway in Fairburn. The defendant lives at that address with her mother, Miss Felice Ray. She and her mother were arguing on this incident date. Her mother asked her to stop cursing in front of an 11-year-old, and she got upset and took her mom's mailbox off the post and threw it. Our office has been in touch with the mom today, Miss Ray. She states that everyone lives together at the incident location. She confirmed the events in the warrant. She stated that the defendant has since paid her back for the mailbox to be fixed. She said nothing like this has ever happened before. They've been living together since this incident without any other issues. She would like contact and for the defendant to return. Judge, this is this defendant's first arrest. The state's requesting a signature bond through pretrial services, taking complete an anger awareness course, no further violent contact with Felice Ray, no weapons, drugs, or alcohol while out on bond. And if the court can sound for Miss Ray, thank you.
All right, Miss Felice Ray.
Yes.
Miss Ray. All right, nope. Go ahead, PD McLean. Oh, I do see Miss Ray. I'm sorry. Miss Ray, do you wish to address the court today? Yes or no?
Yes, as the the
Hold on.
lady,
My first question was yes or no.
yes,
And I don't need you to repeat the facts for me or repeat anything that I've already heard. And so I just will ask you 2 questions after I swear you in. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
yes,
All right, put your hand down for me. Are you in fear of Miss Pierce, your daughter?
no,
You want to have any further contact with her?
yes,
All right, and you feel you'll be safe going forward, residing with her?
yes.
All right, that's all I need to hear from you for today. Any cross-examination?
No, Your Honor.
Okay. All right, you can mute yourself for me, Miss Ray. Let me hear from you, PD Cook.
Yes, Your Honor, we would be seeking, this occurred again in February of 2023. They've been living together, is my understanding, and peacefully since that time. We would be seeking a signature bond to the jail, no further violent contact, and we would object to any anger awareness course at this moment, given the length of time it's been since the incident.
Okay. I will order $1,000 signature bond I'm going to order that through the jail. I'm going to order no further violent contact with the victim, Ms. Ray. No drugs, alcohol, weapons, or guns while on bond.
How much was the bond, Judge?
1,000.
All right, thank
You
you.
get your bond through the jail, yeah.
This is going to be number 17, Ms. West.
Oh, I represent Miss West. I just missed a call from one of the phones. I'll have to return that in a moment. One of the phones in the courtroom.
Okay. This is 24 CR 005844A. Shronika West charged with 1 count of simple battery, 2nd count of disorderly conduct. Pretrial.
17 total. Resident of Pelham, Georgia. Last arrest was in July for battery. 2009 simple assault, carrying pistol without a license conviction. 09 probation. 06 simple battery DV conviction. That's it.
Your Honor,
All
that's
right.
my case. This is an incident from April of this year, April the 8th. It occurred at a employer. Warrants were not obtained until the end of July after an investigator was able to follow up. Police were called between 9 and 10 p.m. to 3200 Howell Mill Road. That's an assisted living facility. The victim, Nicole Casales, she's on the Zoom. We've been in contact with her. So if you would sound for her when I'm done. She was 7 months pregnant at the time of this incident. She reported that she'd been assaulted by a coworker and there were witnesses on scene. While in the break room, the defendant approached her. There were words exchanged and the defendant had to be held back by another person from assaulting the victim who was visibly pregnant. So instead of assaulting the victim because she couldn't reach her, the defendant spat at her. This was captured on surveillance. The surveillance was provided to law enforcement. Both the victim and the defendant actually lost their job as a result of this. Witnesses also completed statements. Video and audio of the incident show the defendant not only spit on the victim as she's being held back, but yell at her, "Bitch, I'll do it again." So that is the basis for the charges in this case, Your Honor, an offensive harm for the simple battery, spitting on her, and then fighting words and disorderly conduct in the assisted living facility. The victim reports she'd never even engaged with the defendant before. They'd never had any altercations or interactions either. She's not sure why this issue happened, but nonetheless, she also lost her job. She's requesting no contact, which the state believes is appropriate. The defendant has history since 2002, and that includes every single charge besides one. So that's 9 prior cases that I see are all assaults, Your Honor, mostly out of Mitchell County. We'd be asking for a $2,000 surety, no contact with Ms. Nicole Casales, and that's Cassells. We would request an anger management class and no drugs, alcohol, or weapons while on bond. And if you could sound for the victim, Mrs. Nicole Casales, I believe. Thank you.
Okay, Nicole Casales. See someone signed on. You wish to address the court today, Ms. Casales?
I do.
Okay, raise your right hand for me. Do you affirm the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, put your hand down for me. Are you in fear of Miss West?
I am.
Do you want to have any further contact with Miss West?
No, ma'am.
Okay. And what's the is there a relationship or are you co-workers? That's right.
Just
Former
co.
co-workers. Just
Yes,
co-workers.
ma'am.
Okay. All right. Any cross-examination?
Y'all aren't co-workers on anymore, right?
No, sir.
Okay.
There's no opportunity. No, there's no way y'all run into it, right?
Not to my knowledge, no, sir.
Thank you. That's
All
all.
right. Okay. All right. Tell me what the state's recommendation was again.
Your Honor, we're asking for a $2,000 surety based on the criminal history. This defendant was just arrested, I believe in July, was what pretrial said and what my records show as well. She's got multiple convictions, misdemeanor convictions for assault, battery, disorderly, carrying a pistol without a license, and assault. So we're asking for anger awareness class, no drugs, alcohol, and weapons, and absolutely no contact with the victim. We'd ask for a $2,000 surety bond.
Okay.
Your Honor,
Mhm.
this is not where I'm not trying to try the case here. My police report copy has got the opposite party being held back, but that be that as it may, this is not the trial and not the place to actually figure out what the jury's going to do. Your Honor, my client is working. Let's see, she is a CNA and working on phlebotomist training, and she is from Mitchell. She left Mitchell County to further her career and to stay away from people, tend to get people in trouble. So I would ask the court to consider a signature bond with no contact whatsoever. The anger awareness we're not going to object to. And of course, stay away. And there's no reason for these two people to contact each other or to run into each other. If they do, they should just go 200 yards the other way.
All right. I am going to, based on the history and the allegations here, order a $2,000 surety bond, $1,000 on each charge. And I'm going to order obviously stay away from the incident location. I guess she doesn't work there. She won't go back there, but I'll just order that stay away. No further contact with the victim, Nicole Casals. Not sure if I'm
Yes,
the
ma'am,
last
Cassels.
name. Casals, okay. No further contact with her. And she must stay 200 yards away from her. Don't talk about it on social media. Don't contact her by phone or third parties or any other means. And no drugs, alcohol, weapons, or guns while on bond. And I think that's all out order at this time.
Position number 9, she's a conflict, so we don't have a conflict of terms.
Where is she?
She's here in front of the camera.
Oh, all right. So we don't have a conflict defender, so we'll have to reset your case to tomorrow.
Who is this again?
9, Sally.
Ma'am, Your Honor,
Yes.
I would like to go pro se, please.
All right, you understand the consequences to representing yourself.
Yes, Your Honor.
Okay. All right, this is 24 CR 005831A. Camilla Salahudin, charged with 1 count of simple battery family violence and the 2nd count of battery family violence. Pretrial.
10th arrest. Last was 2023. Probation probation. 06 battery, simple battery, first offender. 04 simple battery conviction. That's it.
Mm-hmm.
Your Honor, that's my case. This is a dual arrest with position number 2, I believe, Mr. Armstrong. This incident occurred on the 15th of August at about 2 p.m. Police responded to 112 Summer Terrace Lane in Sandy Springs. Both Mrs. Saladin and her cross-defendant, Mr. Armstrong, spoke to police. They live together and have been in a relationship on and off for the last 15 to 17 years. They both gave conflicting accounts of what had happened, but both admitted that there'd been a physical altercation to which they both engaged, and both individuals were seen to have visible injuries. The defendant in front of you said that during a verbal argument, her co-defendant came into the bathroom and he tried to drown her in the bathtub. She said she pulled his hair and that the altercation ended at that point. She said she got dressed. They started arguing again and he pushed her, so she pushed him back. She struck him in the head. He grabbed her by the hair and she says she bit him on the leg. The victim told police she was making the report because she's worried more physical assaults will happen again. Her co-defendant and Mr. Armstrong in position 2 was not on the scene when police arrived, but they spoke to him on the phone. He reported that the altercation had begun there in their house, that the defendant was intoxicated. Mrs. Saladin was intoxicated and started pulling his hair and striking him. He reported that he'd been bit on the leg. He did was seen to have a bite mark on his leg. That's the basis for the battery, Your Honor. She admitted to pulling his hair. That's the basis for the simple battery. Mr. Armstrong reported that, again, she was intoxicated and was striking him and he pushed her off. She bit him and they continued to fight and they fell into the bathroom during the struggle. Your Honor, Mrs. Saladin, the defendant in front of you, was seen to have bruising on her arms. This was a report after the fact. Mrs. Saladin made a report, and when she spoke to police, she couldn't really remember when the incident had happened. In the report, it says she said maybe last Thursday or Friday. She didn't understand how she'd received the bruising on her arms. And so it's the state's position that alcohol is involved and is an issue here, but there is clearly injuries sustained by both individuals. Mrs. Saladin has prior DUI convictions, including a DUI with her child present in the car, an aggravated assault conviction, and a subsequent probation violation as a result of that in DeKalb. She also, before that, had an aggravated assault case that she received first offender on. I believe that was subsequently revoked. Based on her history, we'd be asking for a $3,000 surety bond, Your Honor. Absolutely no contact with her cross-defendant, Earl Armstrong. Stay away from the location. Again, that's 110 Summer Terrace Lane. And we request that she be ordered to submit to random screens. Thank you.
Your Honor, I would like to enter information.
I'm sorry, you're representing yourself. I apologize. Let me ask you a couple of questions.
Yes, ma'am. Yes, Your Honor.
All right. You are how old?
I will be 41 on September the 12th.
Okay. And do you work?
I am currently supposed to start a new position with Chess Zone as an assistant director tomorrow at 10:30 a.m.
Assistant director of what?
Chess Zone is after school activity provided for after schoolers from anywhere from kindergarten to 12, where you teach them chess. There's also an additional one for a general manager position at Goodwill, in which I'm waiting to hear back from them to make my decision between the two as it pertains.
And you're from Georgia?
I'm from Connecticut originally.
How long have you been in Georgia?
I've been in Georgia about 20 years.
You have children or anything?
I have a 22-year-old son.
Do you have any other family here in Georgia?
I do not have any other family here in Georgia. I do reside with Earl Armstrong, which is here present today in the courtroom. We do share a mutual apartment. I have been provided additional resources to look into in case that there are some differences between us when it comes to our living situation, which I would like to look into. I do ask for a signature bond with no violent contact towards Mr. Earl Armstrong. And I would also like to interject that Miss Anna's statements are very incorrect. First off, starting with
Hold on a second. Not gonna debate some of the facts of the allegations with you. I'm trying to determine today your bond and whether you'll come back to court and all those kind of things, and if you're flight risk or not.
Yes, Your Honor.
Yeah, so I won't go into the details or the facts at this point to that specificity. So just making sure that you have sufficient ties here and you will come back to court.
Yes, Your Honor.
And so my concern is with you and Mr. Armstrong. This just happened on the 15th, a few days ago, and whether you all have cooled down enough to not get into any more altercations. Whose name's on the property? Is it a lease or a purchase?
It is a lease, and Mr. Armstrong's name is on the property.
Okay, not yours?
Not mine at the moment.
Okay. How long have you all been residing together?
When we came back together on our 17th year, it was about a year and a month within the residence of 120.
Okay, do you have somewhere else to go stay?
I do not.
Do you think he does?
He does.
Are you going to be residing there if you were to get out, or are you going to be moving?
Yes, Your Honor.
Which one?
Residing at the property.
All right. I'm going to
Your Honor, if I could just interject a moment, I'll be representing Mr. Armstrong here in a moment. His name is on the lease. He doesn't have anywhere else to go. Obviously, there's a concern of keeping them apart, but he seems to me he would be the favored one towards returning to the Summer Terrace Lane apartment.
okay. All right, I am going to order a $3,000 signature bond through pretrial. And that breakdown will be 2,000 on the battery, 1,000 on, well, 1,500 each. I'm sorry, just split them. 1,500 each for a $3,000 signature bond through pretrial, level 1.
Well, level 2 is fine.
I mean, level 2. Okay. And let's do level 2. I will ask her to take 1 week anger awareness course. I'm going to ask that you stay away from the incident location, and maybe you all, well, I don't know, she'll have to find some help on placement, but I'm going to order right now to make sure that this has had enough time to cool down, that you stay away from the residents there, and have no further contact with Mr. Armstrong.
Yes, Your Honor. I do have belongings at that property. Am I able to go pick them up?
I'm going to order that you secure a one-time law enforcement escort to return back to that property to get your belongings. Do not go back by yourself. When you get out, you need to secure the services of law enforcement to go back to get your personal belongings.
Absolutely. And being the fact that I have no other option as far as housing, are there any resources that are available to me immediately to be able to move into with my belongings?
I don't know. That is not something I can advise you on. Maybe check with social workers or some people there at the jail possibly, that may give you some direction, but I don't personally have that information to advise or give to you.
Okay.
That's one of the consequences of representing yourself, is that
Yes,
you've got to figure that out for yourself. So maybe once you get out, you can try to see if you can get some assistance in securing representation. Okay.
absolutely. Thank you, Your Honor.
All right. You're welcome.
Next, it is number 2, Armstrong.
All right. 24 CR 005834J, Earl Armstrong, charged with 1 count of battery family violence. Pre-trial.
It's his 10th arrest, 2022 DUI, 02 simple battery conviction. It was level 1.
Huh?
Level 1.
Thank you. Okay.
Your Honor, the state is requesting in this matter a signature bond through pretrial services for Mr. Armstrong. No further contact with Ms. Salhedden, not a stay away since she's staying away. The anger awareness course through pretrial, no weapons, drugs, or alcohol while out on bond. Thank you.
All right. You all have any objection, P.D. Cook, to a signature bond through pretrial?
No objection, Your Honor.
All right. I will order a $2,000 signature bond through pretrial level 1. 1 week anger awareness course. No further contact with Camilla Salahudin. And no drugs, alcohol, weapons, or guns while on bond. Anything else?
No, Your Honor.
Okay.
Position 10.
This is 24 CR 005847F. Connor, is it Sayer? Sayer.
Yes, ma'am.
All right, and that's Attorney J.G. Wall.
That's correct, Your Honor.
Okay. All right. And this is 24 CR 005847F. And he's charged with 1 count of battery family violence, a 2nd count of criminal trespass and damage to property. Pre-trial.
7. 2023 criminal attempt to commit a felony, aggravated assault. On probation for aggravated assault out of Gainesville, Georgia. Back in February, they gave him 10 years probation. 2019 probation, 2019 simple battery DV, trespass conviction. That's all.
Okay.
Your
Okay.
Honor, that's my case. This is a dispute between roommates. Police were called on the 11th of August at about 11:45 p.m. to 355 Misty Lane in Alpharetta. The victim, Jonathan Tansil, that's Jonathan, and Tansil is spelled Tansil, reported that during an argument with his roommate, the defendant tackled him on the sofa and repeatedly punched him in the face. He was seen to have bruising to the bottom part of his face and a busted lip that was bloody. The victim had blood all over his shirt when police responded. In addition, his glasses were damaged when he was repeatedly struck in the face by the defendant and broken. When police arrived on the scene, the defendant and his girlfriend had fled the location. This defendant did just get a first offender aggravated assault status on a Hall County aggravated assault in February of this year. We did speak to the victim. He reported that they're roommates, and he confirmed the information in the warrant, said that nothing like this has happened before. We're asking for no contact, Your Honor, and to stay away from the location. Again, that's 355 Misty Lane. No drugs, alcohol, or weapons while on bond, a one-time police escort to get his belongings, and we'd ask for a $2,000 surety, Your Honor. That's $1,000 on each charge, based on the defendant's criminal history. There's also obviously a risk to reoffend and a risk to intimidate the witness and victim. Thank you.
Judge, Mr. Sayer and his girlfriend were never interviewed by the police. They actually left the scene because of Mr. Tansel, who was the instigator who began the violence that first started against Mr. Sayer's girlfriend, and then Mr. Sayer came to her aid. To our knowledge, law enforcement has never attempted to make true contact with Mr. Sayer or a witness in this case. We would ask for a $1,000 surety bond. We have no objection to any of the other conditions that were requested by the state. He and his girlfriend do intend to leave and move out as soon as they can.
Okay. And how old is Mr. Sayer?
Off the top of my head, I don't remember. Miss Sayer, how old are you? Maybe.
I'm 24, yeah.
24. Okay. And I didn't hear, or did I miss it? Is he from Georgia or not?
He is, Your Honor.
Okay. And working?
Mr. Sayer, go ahead. Shall I swear him in, Your Honor? Sure.
That's okay.
Connor, raise your right hand for me. Do you solemnly swear the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down. Connor, are you working at this time?
Actually, at this time, I've just been doing DoorDash to fill in a recent gap. I'd actually lost my job as a diesel mechanic at Ryder. I was a mobile diesel mechanic, so I have been doing what I can to fill in gaps while I look for.
All right. I'm going to order the $2,000 surety bond. 1,000 on each of the charges. And with that surety bond, I'm going to order the stay away from 355 Misty Lane. And then no further contact with the victim. Is it Jonathan Hansel? And I forgot to sound for him. I don't know if he's here on the Zoom.
Yes, Your Honor, that's his name, and if you wouldn't mind, thank you.
I didn't see it. Sorry about that. Mr. Hansel?
Hello.
Yes. Do you wish to address the court today? Yes or no?
Yes.
If you do, you have to turn on your camera. I have to see you and swear you in.
Yes, ma'am.
All right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
Put your hand down. Are you in fear of Mr. Sayer?
Yes.
You want to have any further contact with Mr. Sayer?
No.
Okay. All right. Any cross-examination questions from either counsel?
I just wanted to confirm.
No, Your Honor, thank you.
Hold on. All right.
No,
Anything,
Judge,
Mr. Wall?
not based on the court's questions. No.
Okay. Did you have a question, Mr. Hansel?
I just wanted to put in correction that the address is 335 Misty Lane.
Oh, 335. And who resides there?
I currently am leaseholder, and Connor Sayer is also a leaseholder there.
Okay. How long have you resided there?
We moved in December.
Okay. All right. I will order that $2,000 surety bond, 1,000 on each. With that surety bond, I'm going to order Mr. Sayer to stay away from that location for now. No further contact with the victim, Mr. Tansel. And no drugs, unprescribed medication, alcohol, or weapons while on bond. And I believe that's all out order at this point.
Judge, just so I'm clear, I've actually never, I don't think I've ever seen a bond order from Your Honor. Is it made explicit that he can contact law enforcement to go get his things from the home?
I will put that in the order because
Okay,
it's
thank
not,
you.
yes. And I will allow one-time law enforcement escort, Mr. Sayer, for you to go back. Please don't go back without law enforcement to get your personal belongings. But he's got to stay 200 yards away from the victim, Mr. Tansel. Have no further contact by third parties, no social media post about it, and no contact by other third parties while on bond. And that should do it.
Your Honor, thank you.
All right, you're welcome. Thank you, Mr. Wall.
May I be excused?
Yes, you may. Thanks.
Thank you very much.
And you're excused also, Mr. Tansel. I'm sorry, Deputy, go ahead.
Position number 3, Carter.
Okay. This is 24 CR 005836Y, Cedric Carter, charged with 2 counts of battery, pretrial.
Fourth arrest, the last was 02. Probation, ag battery, possession of a firearm by a convicted felon. Possession of a firearm during the conviction. That's it.
Okay.
Your Honor, this incident happened back in March, on March 24th of this year. Officers responded to 3775 Zip Industrial Boulevard in Atlanta. This is a coworker dispute. The victim in this case, his name is Christopher Adams. He is the defendant's coworker. He told police that the defendant had asked to use his phone. He let him use the phone. The defendant returned the phone. There was some kind of argument over accusing the victim of deleting a text that he had sent or something of that nature. And the victim denied deleting those messages, and the defendant started shoving him and then punching him repeatedly. The victim was pretty seriously injured, Your Honor. He had swelling to his right eye, a gash above his right eye. His front tooth was broken in half, and he had loose teeth. Your Honor, I understand that this defendant has a fairly limited criminal history, and that is because he was convicted of aggravated battery in 2003, and he was sentenced to serve 25 years in prison for that. I don't have the facts of that case, but based on his charges being aggravated battery, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon, my best guess is that this defendant shot somebody and was serving prison time for that. From what I can find online, this defendant was released from the DOC September 8th of last year. So he's been in prison for some time. He gets out of prison, and less than a year of his release, he's very seriously injured a coworker. Plain and simple, this is a public safety concern. Attacking a coworker over a text message, and to the extent that he injured him is very concerning. And again, Your Honor, he's been out of jail less than a year, and he's also got a hold for a parole violation. This individual is a danger to the community, and there's a risk of reoffense here. We have been in touch with Mr. Adams. He states that they were coworkers. He confirmed the events in the warrant. He states that his tooth was broken and he had to pay $1,109 to have that tooth repaired. He states that both of them were fired as a result of the incident. He has not seen or spoken to the defendant since this incident and does not want any contact. I would like for him to stay away from his residence as well, which is 3607 Hancock View in Decatur. The state is requesting in this case, Your Honor, there's 2 counts of battery. The state's requesting a $5,000 surety bond on each count. Absolutely no contact with Mr. Adams. 10 take an anger management course, no weapons, drugs, or alcohol while out on bond, and to stay away from the incident location and the victim's residence. And I believe Mr. Adams is on the line, Your Honor. Thank you.
All right, Mr. Adams.
How you doing?
Fine. Do you wish to address the court today, yes or no?
Yes.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. Are you in fear of Mr. Carter?
Yes.
You want to have any further contact with Mr. Carter?
No.
All right. Any cross-examination by either counsel?
Not from the state, Your Honor.
Okay. Who's representing the defendant?
I'm sorry, Your Honor. Your Honor, it's our position of the defendant that he was acting in self-defense and that the alleged victim pulled a gun on him at the time, and that's what prompted the altercation, or at least the physical part of the altercation.
Okay.
We obviously have no objection to stay away or no further contact. We would, now that he's out of work, we would ask the surety bond to be as low as possible. And beyond that, we'll leave it up to the judge's discretion.
Is your client working now?
Let's see. Yes, he's working in a landscaping business, Your Honor.
Georgia resident?
Yes, 45 years.
I'm going to order the $5,000 signature bond through pretrial. And with that signature bond through pretrial, and that's $2,500 on each. I'm going to order stay away from the incident location and stay away from the residence of the defendant. I am going to order him to take 2 weeks of anger awareness courses through pretrial, and I'm going to put him at a level 2. No further contact with the victim, and no drugs, alcohol, weapons, or guns while on bond.
That's per judge.
Per judge.
Your Honor, for the record, the state would just object to a signature bond in this case, given this defendant's very serious criminal history and the fact that he's been out of prison for less than a year and has already committed a very serious offense against another individual.
All right. Next.
Number 6, Perkins.
CR 005839A, Bobby Perkins, charged with 1 count of battery, family violence. Pretrial.
27. 2023 probation. Got an open battery DV in state court. You want the case number or you want me to skip it?
You can skip it.
On probation, not a car for robbery. 2022, 2020 probation violation. 2019 probation. 2014 possession of a firearm by convicted felon conviction. 09 battery conviction. That's it.
All right, state.
Your Honor, this incident happened back in March. On March 29th, 2024, officers responded to 195 Chica Mwaga Place regarding a dispute. The victim in this case is Tia Wine. I'm sorry, I'm going to pronounce it. Tia Winnie Summers. She and the defendant have a child together and they live together. She advised that she and the defendant were arguing when he grabbed her by the neck and slammed her up against the refrigerator and then grabbed her and threw her onto the kitchen table, causing her head to strike a wax melter. The victim had 2 lacerations to her forehead. Judge, this defendant also has an open battery family violence case against a different victim that lives in that same household, 23 CR 001771A. The victim in that case is this victim, Miss Summers' mother. Her name is Rochelle Summers. He is accused of grabbing her and trying to forcibly remove her from the residence, causing scratches to her arm. Your Honor heard the first appearance in that case and ordered no contact and a stay away from that residence. However, the bond was later modified to an SOB, no further contact with Miss Rochelle Summers, and there was no stay away. This incident did happen after that bond order was in place, so he's not in violation of that bond as far as the stay away is concerned. However, it is a new crime, and so the state's position is that he's in violation of that bond by committing another crime, Your Honor. And of course, because this is the same incident location at this point, the state's certainly going to request a stay away and no further contact. I understand that this happened about 6 months ago. However, given his 27 arrest cycle history and the violence within the home, and now this being the second victim in this case, and this victim being in a position where she is reliant on the defendant for childcare, the state's position is that the risk of reoffense is high, and there's also a risk of intimidation and danger to this victim. The state would request a $5,000 surety bond, Your Honor. No further contact with the victim in this case. Stay away from that 195 Chiamwaga Place. No weapons, drugs, or alcohol while out on bond. And I know Your Honor typically sometimes will do a cash bond in this case. The state would have no objection to a cash bond of $2,500 or higher. In the alternative, if Your Honor would prefer that, and if the court can sound for Ms. Summers, thank you.
All right, Ms. Summers. Ms. Summers. All right. TD Cook.
Yes, Your Honor, my client is 33 years old. He is currently working in the moving business. They have lived together. They do have a child together. I've not been able to contact Miss Summers, so I don't know quite what her feelings are at this moment. It has been a while since the incident. We have no objection to a stay away or no further contact. We would like the surety bond to be as low as possible. And if there's an anger management element to this, we would not object to that either.
I understand. So this is the second case against a victim in the same home.
Yes, Your Honor. In candor, I don't know at this point if Miss Rochelle Summers, who's the mother of the victim in this case, still lives at that address because the bond was changed to remove the stay away. Perhaps she has moved out since that time. I don't have that information, but at this point, this is the second victim in the same incident location as the last case from 2023.
All right. So the bond that he received before was 1,000 SOB before, or no? What was the previous bond?
The previous bond, Your Honor, was a $3,500 SOB through the jail. No further contact with Rochelle Summers, and that was by Judge Roth.
Okay. Until now, it's Tioni Summers, which we
That's
assume
correct, which is the
related
last
to
victim's daughter. And it's my understanding that all 3 of them lived together at the time of the incident that happened last year. And whether or not mom still lives with them is unknown.
Okay. Your client, Mr. Cook, has his hand raised.
Ms. Perkins, I would not speak, unless you have some, well, she has not given an order on the bond, but I would not speak at this moment. You may incriminate yourself. Would not be wise.
All right, I'm going to order a $2,500 cash bond. And with that cash bond, it's going to be a stay away from 1995. And I don't know how to pronounce the name of the street, couldn't spell it. I know it was Chick something.
Chicamauga Place.
Chickamauga.
Chickamauga.
Yes, Chickamauga.
Yes.
No further contact with the victim, Tioni Summers. And no drugs, alcohol, weapons, or guns while on bond.
And Your Honor,
Something's
I
going
don't know
on
if I
there.
said this already, but we have not been in touch with Miss Summers today, but we have tried to reach her.
No, there's no further contact with her, and stay away from that incident location so we can make sure things have cooled down there, or can figure out what's going on. And with the history of Mr. Perkins, don't know if I feel comfortable doing anything else but a cash bond right now. All right.
Position 12.
This is 24 CR 0058480 Desmond Sexton, charge of 1 count of battery.
Second arrest.
Okay.
Previous was some window tint, possession of marijuana, possession of a knife or a firearm during the commission, out of Clayton County. That's it.
And this is my case, Your Honor. This defendant was arrested and came in with warrants for 3 different cases. One of which is the misdemeanor in front of you today. He's also got felony level criminal damage to property, I believe. He was in felony court this morning, or should have been. The incident in front of you is from the 19th, so yesterday, between 12:30 and 2 in the afternoon. Victim Aaliyah Crouch, Crouch, reported that she'd gone to get her hair done at a location where the defendant works nearby. They have a previous relationship, but are no longer seeing each other, as far as she has revealed to us. They engaged in an altercation, or he argued with her because she was there. She was getting her hair done at the salon nearby, and the defendant came up to her and was putting his phone in her face and threw liquid on her. He then began to strike her in the arm. She had visible injuries to her arm. She reported that they have had arguments before, but said that they were never physical. I would say that there are prior calls to police by the same young woman for assaults by her, or by this gentleman on her in the past. So although she says she's not in fear, there have been prior incidences. We'd be asking for a $2,000 SOB through pretrial level 1 because of his lack of criminal history, although I do believe he's in felony court as well. No contact with the victim in this case, Aaliyah Crouch, and no drugs, alcohol, or weapons while on bond. If you might sound for Mrs. Crouch in case she decided to join us. Thank you.
Thank you. Aaliyah Crouch. Aaliyah Crouch. All right. Go ahead. Which PD?
I've got that.
Okay.
Your Honor, I believe I looked up on Odyssey, and if I have the correct case, today at 11:30 court session, he got a UJR. He works for a barber at a barbershop which has been open 11 years. And I suppose he's working on certifications or apprenticeships or whatnot. working under that barber. The incident was, yeah, that was yesterday at noon, and I had looked at something else, but there was something on the booking sheet which I believe is incorrect, or apparently something 8 years old from high school, something about some other matter. So on this, Your Honor, we would ask the court to consider, since he is employed, and because the other case will not interfere with his freedom, we would ask the court to consider giving him a signature bond. There's not any reason for him to have any contact whatsoever with her, and he would promise the court to absolutely stay away from her and her residence and her place of business and that sort of thing. There's also no reason to think he wouldn't make court. He does have a stable address that's in the booking sheet, and his mother's phone number is there. He's local, although he's born in Thomasville, that's South Georgia. That's quite some time ago. He's a local person.
All right. And what was the state's recommendation?
Your Honor, we requested a SOB through pretrial level 1 and no contact and no drugs, alcohol, or weapons. We asked for $2,000.
All right, I will order that $2,000 SOB through pretrial. Level 2. And no further contact with the victim, Alicia or Leah Crouch. Stay away from the incident location. No drugs, alcohol, weapons, or guns while on bond.
Your Honor, I believe the incident location is where he works, so we wouldn't be asking for that.
Okay, so no stay away. All right. And I will also order, since it's through pretrial, 2-week anger awareness course. I think that'll do it.
Thank you.
Thank you.
Position number 8, we were waiting on a Spanish interpreter for her case. Ms. McClain did not put in for a Spanish interpreter.
Right. I didn't get a chance to find out, Your Honor, how much English she had or did not have because she was in medical. And now I understand she is definitely in need of a Spanish interpreter. She's not in medical, she's in the courtroom.
I told you she needed a Spanish interpreter earlier, Mr. McClain.
Right. We always want to talk.
Position number 13, Stephen.
So, Miss Bridgewater or Miss Lewis, are you all able? Miss Lewis, are you able to see about a Spanish interpreter this late day?
I can just hope for the best. I can try. That's all I can do.
Yeah, we may have to reset that. It's 3:45. See what you can do. And then what was the other one, Deputy?
This is position 13.
13. 24 CR 005841Y, Christian Stephan, charged with 1 count of battery family violence, 2nd count of simple battery family violence. Pre-trial?
16. Last arrest was 2013, suspended license. I didn't see any violence in his history. Level 1.
That's my understanding too, Your Honor. This is an incident from June the 18th. The victim, her name is Keisha Carter. She is married to the defendant. She called police on the domestic and reported that there had been an argument which became confrontational. Her husband, the defendant, Mr. Christian Stevens, slapped her in the face. She responded by hitting him with a stack of mail she was holding. And then he grabbed her by the arms and or neck as well and shoved her into the kitchen counter. The altercation stopped when their 16-year-old Krista Stevens entered the room. She was seen to have a scratch on her neck as a result of being grabbed by the neck. She refused treatment. This was not a serious incident as far as injuries goes, Your Honor. The defendant has history, but it is not recent and not violent. We have been in touch with Mrs. Carter. She is on the Zoom. She reported that these incidents happened, but nothing like this has ever happened before, and there's been no violence since. I did do a review of APD police reports, and that is true. There have been no calls for violence or issues at that location. She's asking for no violent contact, and so we would join with that. We would like a $2,000 surety bond, Your Honor, no violent contact with Mrs. Keisha Carter, and no drugs, alcohol, or weapons. Thank you.
And no stay away.
No, Your Honor.
All right. PD.
It's me, Your Honor.
Yeah, your camera's off.
Oh, let's correct that.
Okay.
You're muted.
Oh, yes, you are.
If it's one thing, it's another. Thank you very much. We would ask the court to consider a signature bond because of the 2013 date of the last arrest and the nature of the other things not being violent, Your Honor. We would agree, of course, with the no further contact, and we would agree to any other reasonable conditions the court would want to put on it. But he does work, and if I might turn to that, excuse me. Your Honor, he has a friend who also joined the Zoom and could confirm that he is a relief operator at a Publix bakery operation. And so he's kind of the utility person that fills in for whatever task anybody's not doing or is out on. So he's very industrious, good. He's got a good income for that. But we would ask the court to consider a signature bond.
And this is his wife.
Yes.
Yeah, I thought there was 16 cycles.
The 16-year-old walked in the room, and that's when the altercation stopped.
His cycles are, there aren't 16, I don't believe, but pretrial can correct me, but the last cycle that I saw was in 2007 that was related to an actual crime and no violence in his history, Your Honor.
Okay. All right, I'm going to order a $3,000 signature bond. I will order that signature bond through the jail. I'm sorry, through pretrial. Signature bond through pretrial for $3,000, $1,500 on each. I'm going to order 1 week anger awareness course. And no further violent contact with the victim, Mrs. Carter. So 3,000 SOB pretrial. And I guess it'll be level 1. Anything else?
Nothing.
The interpreters in traffic court. But she'll try to join us.
She's getting ready to log on soon, Judge.
She ain't in rush hour traffic, is she?
No, traffic court.
Oh.
Not her.
Oh, I'm sorry. I didn't see the court at the bottom. I'm sorry. What level was
Reading is
that?
fundamental.
I know it. Reading is fundamental, they said. That was level 1.
Well, had they been prepared, we would have already dealt with this by now. Thank you.
Uh-oh. He's getting on you, Mr. McClain.
Yep.
Position 18, Williams.
I'm sorry to make you laugh. Say that again, Deputy.
Position number 18, Williams.
All right, 18. This is 24 CR 0058445B. Billy Williams, charged at 1 count of simple battery against a police officer or detention officer.
Got 56
trial.
total, 56. It has a FS charge, I did see. 2020 probation, 2021 battery dismissed, 2021 destroying the property of another conviction, 2021 engaging in lewd conduct conviction, 2021 petty larceny conviction, 2020 battery on protected person conviction, 2020 false statement conviction, 2020 battery conviction. Man, that was not his year. 2020, I got 2 trespass convictions, 2020 petty larceny conviction, another 2020 battery conviction. I stopped there.
Okay. Okay.
Your Honor, that's my case. This is an incident that occurred on the 19th at about 2 a.m. at Grady, actually. The defendant, who was booked in on aggravated assault and aggravated battery for felony charges today at the same time, he was being transported. He was being picked up from Grady and taken to the jail by Officer Jamison. She was going to transport him. His hands were restrained. He started to resist by tensing his arms and pulling away. And then he turned around and spit in her face. She returned him to Grady, and he was taken by another officer to the jail. So he was in first appearance, I believe, this morning. He does have a substantial history. So the simple battery is for spitting in the officer's face. We're asking for a $2,000 surety, Your Honor. No drugs, alcohol, or weapons while on bond.
Okay. P.D. McLean.
I'm sorry. Which client was that, Your Honor?
I'm sorry?
Billy Williams?
Yes.
Okay, let me take a look at that. I just I've got that over here. I'm sorry, I hadn't interviewed Mr. Williams yet. I don't think I do have the paperwork as part of the stack, but I was not on the phone with Mr. Williams today.
You like to reset him? What are we doing?
I would like to talk to him in a breakout for just a moment, but I've got to figure out why that has occurred.
Okay, you're pushing us today. It's Tuesday. And then we have one other one in the courtroom. Who is that? Is that 15?
No, it's Mr. Thomas Broughton, but he's not on the calendar, but he was on our pull sheet today.
Your Honor, there was a little mix up with that case. This case was before, well, it wasn't before the court yesterday. I NOD'd a misdemeanor case yesterday from this individual. There's also another case from an unrelated incident that needs to be heard. The clerk's office contacted me. I've accused the case, and I believe it has a case number at this point. Yes. I'm ready to proceed whenever the court's ready. I can give you the case number.
Ms. Lewis, is this another add-on?
What's the name of this person again?
Thomas Broughton, Mr. Jordan.
Yeah,
probably
that's the add-on I sent over to you. Said that you couldn't open up.
Oh, okay. Oh, that's the Thomas Broughton. I see it. I'm sorry. And then was it one more besides the interpreter case? Or that's it?
No, the interpreter case is our last person. Position number 5 went downtown, and position number 2, he refused. He refused to interview. He refused totally.
So when you say 5 went downtown, you mean to Grady?
No, he went downtown court. I'm sorry.
Oh.
So are we resetting him?
Well, he's not here. I guess so.
Okay. So we'll reset position 5, Mr. Harris, till tomorrow.
What about position 15?
Position number 15, he refused to interview. He just refused totally.
Your Honor, that was a reset from yesterday for the same reason. And so we'll need a waiver, I believe.
Well, if he won't talk to him, I don't know how they're gonna get a waiver, but we'll have to do something at some point.
Well,
When is his,
So what's this reset behavior?
Riverside? Mm-hmm.
Yeah, I would say.
All right.
just so that it's clear, this can't be a Riverside issue at this point.
Because of the reason. Gotcha. Okay.
Your Honor, I apologize. I've got to run. Ms. Deziano is going to take over the interpreter case, and if Mr.
Okay.
Williams is able to talk to defense counsel, could I be excused?
Yes, you may. Thank you so much.
Thank you. Thank you, everyone.
Okay. All right.
Judge, on
Bye-bye.
position number 50,
Hold on. You got cut off. Say that again.
he does have a bond on that case.
On which case?
Brandon Varner, the one y'all see on the reset.
15.
Yeah, he has.
Oh, he does?
Yeah, he has a $5,000 surety bond. I guess that was pre-posted to his booking when he got booked in. They did give him a bond,
Oh, okay.
but I mean,
Good.
but he has not been in front of us. But he does have a total of $5,000 surety bond.
Okay.
Just letting you know. I don't know if that make a
No,
difference.
that's good information. So we can do this while we're waiting on, is Mr. McLean in there interviewing? And who is this?
Broughton.
Oh, that's right. This is the add-on. And is Mr. McLean already gone over there to interview Mr. Williams? In a breakout or whatever we're having to do, or he needs to call?
I
So that
think
by
you're
the
gonna have to
time
call him because I can't put the courtroom in the breakout room.
Duh,
fine.
gotcha. I'm
So
so
I think
used
you're
to
supposed to
saying it.
call him.
Mr. McLean, you know the call? You know where to call?
Yeah, sure. 239.
Go ahead and please do that. By the time the interpreter shows up, we should be ready to rock and roll. Let's do this.
Who's calling now?
And
Yeah,
Mr. McLean, you're not muted.
I'm calling 2392. Yes. Okay.
He's picking up now.
So Your Honor, on that Mr. Varner who already has a bond, do we still need to get a waiver from him?
Maybe not. I mean, we can put that down, but then I think he's still supposed to come before me. But we'll put that in the system, I guess. It's in the system, rather.
Your Honor, I believe it's just a preset bond. I think you're still required to have a first appearance of some kind. Notably, I know everyone argues Riverside, but it's my understanding that the only requirement of Riverside is that a first appearance be had, not necessarily that a bond be set at that
Right.
point.
No, that's what I think ASG Allen was saying. Indirectly, I knew what she meant. It's not at Riverside.
Right.
So we'll keep moving from that one. Ms. Bridgewater.
Okay.
Yeah, he would need a first appearance hearing. If he paid the bond, he would be waiving the first appearance. But as long as he's still in without paying the bond, he gets the first appearance, and Riverside wouldn't be an issue here.
Okay. So we'll reset him till tomorrow for behavior.
Your Honor, I believe the interpreter just got on.
Good. All right, Thomas Broughton, 24 CR 005850J, charged with one count of fleeing or attempting to elude law enforcement, no insurance, and operating a vehicle with suspended registration. Pre-trial.
Third arrest, 2018 fleeing an officer. It was reduced to reckless driving, no low. 2017 possession of marijuana, dismissed.
Okay.
Your Honor, this incident happened on August 12th of this year. Law enforcement were attempting to pull over a 2018 Chevy Camaro when it pinged as having a suspended registration and no valid insurance. When the officer went to initiate the traffic stop, the defendant refused to stop his vehicle and instead accelerated in a blatant attempt to flee from law enforcement. He was not apprehended at that time, Judge. However, that incident happened 8 days ago. Then 3 days after that incident, I'm sorry, my math is bad. 4 days after that incident, on the 16th, he was booked in on a felony matter where he has several charges: reckless driving, fleeing and eluding. He was going over 100 miles per hour in a 45-mile-per-hour zone for that case, Your Honor. And he also has a previous fleeing and eluding case. I believe his bond in felony is upwards of something like $20,000. The state would request in this case a $2,000 surety on the fleeing. And then Your Honor can do an SOB jail for the other two, or in the alternative, a $500 good bond on both of those. Thank you.
Okay. And you said your recommendation on the fleeing was a 2,000
surety.
SOP or surety?
Surety, given his previous history, Your Honor, and then he did do the same thing a couple days later.
Okay. All right, PD Cook.
Your Honor, we're going to leave this in the judge's discretion.
Okay. And just let me know in general where Mr. Broughton is from, just some basics.
He's lived in the Atlanta area his whole life. I think his current residence is with his grandparents in Riverdale. So he's lived here 35 years.
Okay.
His father is in town as well. He has a BA.
Okay.
And Your Honor, I'd also note, I forgot about this part. Yesterday, there was a case before that came into our office that I had to dismiss based on the statute of limitations and there being no exceptions to it. And in that case, it was 2 charges of obstruction, 1 charge of misdemeanor marijuana. But I think the resounding theme here is this individual obstructs officers and runs away from officers and does not follow officers' commands. So just take that into consideration, Your Honor, if you would. Thank you.
Mm-hmm. All right. On the fleeing or attempting, I will order that $2,000 surety bond. It's going to be a split bond, Ms. Bridgewater. And then on the other 2 driving charges, 500 each SOB jail. So 1,000 SOB jail and 2,000 surety, for a total of 3,000 split.
Okay.
Did I do the math right?
You did.
Okay. All right. No drugs, alcohol, weapons, or guns while on bond. And no driving unless you have a valid license and registration and insurance, all 3. Otherwise, don't drive. That should be it. Anything else?
No, Your
Hold
Honor.
on. Okay,
Yeah,
hold on
yes.
1 second.
I've interviewed
What now?
Mr. Williams.
Okay, hold on 1 second.
while we're waiting on the judge to come back, are we doing position number 8 or is that the Spanish interpreter case?
That's the interpreter case.
Okay. And we're also waiting on Mr. Williams here. So, okay, those are the last two.
Oh, by the way, on the Spanish interpreter case, could y'all chat to me what y'all's recommendation is going to be?
Sure.
Okay.
Wait, so did we finish position 18?
Which person is that? Billy?
Billy Williams?
Yeah, Billy Williams. I thought you said you didn't get a chance to speak.
I've interviewed him, but I'm going to tell the judge we need a breakout session that will be extremely brief. He's got a one count with us, and it'll be a very brief breakout session with the state and me and the judge and the clerk.
Okay, but Judge Mincy's already heard the facts on that case, right?
I don't think so.
Oh,
I don't know.
I did.
Well, I gave an
thought
extensive
I
history.
gave
I
him-
know that.
Yeah, it was 56, but I thought,
I'm just trying to figure out what I need
while
because
it
this was missing.
transport. I
Yeah.
thought I ruled for 2,000 surety on Billy Williams. No?
No. Mr. McLean said for some reason he didn't interview him. That was my.
Oh,
I
did I
thought Miss
write it
Allen
on the
went.
wrong case?
No, I thought Miss Allen we went through the whole thing, and then when we got to Mr. McLean, he said he hadn't interviewed her, so we stopped.
Exactly. That's my understanding.
Oh, that was her recommendation. Okay, I'm
Right.
sorry.
Okay, yeah.
Okay.
Yeah.
I'm just
Oh,
trying to figure out if I need to pull up the case docs, that's all.
Yes, please. And I wrote it, and I usually write the recommendation in a different spot, so that was my fault. So I know that was not my ruling. Okay.
No worries.
And this is Mr. Williams before us, correct?
Yeah, but I think he said he needed a brief breakout.
Right. It's
He
MH.
needed a brief breakout.
It is? Okay.
It's MH.
Breakout. Well, is he the only one in the courtroom? We can turn off the recording? I mean, the live stream?
He's not the only one in the courtroom. We still have the interpreter.
Oh, that's right. Which one you want to take first, the interpreter or him? Because if you take the interpreter case, then we can do him last.
We can do him since he's already seated, because he still got to interview her anyway.
Right.
Oh, shoot, that's right.
We're gonna be very quick.
He's gonna owe us lunch and dinner, right, Deputy?
That's right.
Might as well throw breakfast in there too.
And
Breakfast too. Oh, wow, we gotta add the drinks to everything.
Okay, so what we doing, people? What are we doing?
18, Billy Williams.
Okay, so what are we doing? I'm gonna put in the court.
We gotta go in a breakout.
In the
Put
courtroom?
all of us in a breakout.
Me, Mr. McLean, Judge,
Okay.
Miss Thornton, probably.
Who's going in the breakout? That's all I need.
Oh,
to
you
know.
want Miss Thornton in? Okay.
Sure.
We can have Miss Thornton come in.
She can come.
Is courtroom 2 going in the breakout or no?
No.
No.
It's the state, the judge, McLean,
That's
and
what I'm trying
Thornton.
to get clear.
Well, they
Thank
told you
you.
that.
Yeah.
Oh, Lord.
I don't need to go.
Don't get him started. Who said I don't
It's
need
been
to
a
go?
long day. Let's
Miss
just get it
Thornton.
over with. That's, yeah.
You don't want to come in with us, Miss Thornton?
No, ma'am.
Sorry.
I'm trying to get my system. It keep going down. So I'm trying to work on that.
Okay, I got you. You know who's talking about you, Mr. McLean, correct?
What was the bond?
It is a 2,000 surety.
2,000 surety, yes, Your Honor. No ADU,
Yeah,
DHET,
DHET.
and that's appropriate. And like I said, I'll be in touch with his other lawyer.
It's fine.
So we just got one case left, right?
Right.
You
Still
want
owe.
to reconcile, Miss Holly? Well, no, I guess if he's not here.
He who?
And that's the Spanish interpreter case.
So how you guys gonna do this, break out this Spanish interpreter?
Want
to put courtroom 2 in with Mr. McLean then? I think she.
Can you do that?
Yeah,
Yeah, if you can do that.
I can. I'll do it
Okay.
right now.
Thank you, dear.
Holly, you want to go over the calendar with me?
Will they give him, I guess, his information?
Him who?
Do I want to do the calendar, Judge?
Mr. McLean.
You got PD Cook on here.
Okay.
PD Cook, you gonna relay the messages?
Okay, we can go over the calendar.
Yes, Your Honor. Oh,
Okay.
Okay, then, with that being said, once again, the reset date for the SAP calendar is going to be September the 3rd. Position number 1 is reset further notice with a total $3,000 SOB through pretrial. 2 is reset further notice with a $2,000 SOB through pretrial. 3, reset further notice with a total $5,000 SOB through pretrial. 4 is going to the SAP calendar with a $1,000 good bond. 5 is medically reset till tomorrow. 6 is, hold on, the SAP calendar with a $2,500 cash bond. 7, reset further notice with a $1,000 SOB through the jail. 8 is, they're talking about it now. We'll come back to it. 9 is reset further notice with a total $3,000 SOB through pretrial. 10 is going to the SAP calendar with a total $2,000 good bond. 11, reset further notice with a $2,000 SOB through pretrial. 12, reset further notice with a $2,000 SOB through pretrial. 13, reset further notice with a total $3,000 SOB through pretrial. 14, reset further notice with a $2,000 SOB through pretrial. 15 is a behavior reset for tomorrow. 16 is reset further notice with a $1,500 SOB through the jail. 17 is going to the SAP calendar with a total $2,000 good bond. 18 SAP calendar with a $2,000 good bond. And the add-on is going to the SAP calendar with a $3,000 total split bond. Are there any questions, comments, or otherwise?
Number 5 is reset downtown court.
What's that mean?
That he had probably a felony case downtown today, so they brought him downtown.
Okay, so I take off this medical then.
Yeah, they said he was downtown.
So downtown, what do you mean? Where's downtown?
Here.
That
In the
means
courthouse.
Here. Oh, they're
Yeah.
saying Superior Court.
Yeah.
Oh, I
Yeah,
didn't know the lingo. I thought,
yeah,
I'm like, well, where do you get to ride to
I
today?
didn't either. I thought I was talking
yeah.
about a
Yeah,
different
because usually
courthouse.
we say next door
Nah,
or down
cause
down
like
the
when
street means city.
uh like when records do a pull sheet
Mm-hmm.
for all the courts for each day, and they
Mm-hmm.
have a part on there that says downtown courts. So he was brought downtown for something else. That's what they're
Oh,
saying.
okay.
Yeah.
We learn a new
We
acronym,
just
lingo, or something every day.
we just don't have it often. That's all.
Oh, okay. Hmm. Got it.
So now we're just holding on the interpreter case on position number 8. And hopefully that won't be much longer.
Yeah, good luck.
Yeah, you know who's gonna talk about them. Go ahead.
Well, I got
Yeah.
it's a first arrest is what I have, just so you know.
Oh, that's even better. Oh, I wrote that on here already. I think you told me. Good. I have that written. That helps.
And you know what? I'm
Mhm.
having some technical problems with my scanner and everything, so I would say that I'll scoot over and send you the paperwork I have now, Judge.
Go ahead. And yeah,
Okay, all right. Well, somebody just take notes and
yeah.
I'll send
Okay.
this last one over, okay? And
Yes, ma'am.
okay, no problem. Oh. Judge, I'm gonna rush and do this here. I won't have them in numerical order. However, I will have the complete stack, okay?
Okay, that's
All right.
good. So are you scanning? Are you faxing?
You know what? Which do you prefer?
Oh, whatever's
How
easiest.
about if I do them all? Okay, so maybe all bases will be covered.
Okay. Because I
Okay.
saw something about is Fulton County having troubles today?
Oh, say it so. Oh, come on, for real?
Or was it yesterday? I saw an email
There was something
about
with an IT outage today, so
IT, yeah,
I
somewhere.
saw it the other day too.
Well,
I
you
think
know
it
what?
was the second one.
I'm gonna do all 3. Facts,
What you gonna
personal,
do all three?
yeah.
Do 2, but it has been, there's something about, and you know how they do that intermittent. I always have to,
See,
I have a hard time saying that word.
okay. Well,
Yeah, there's some update tonight.
Oh, is it?
Oh, that might just be with my
Oh,
office.
maybe that's what it said. Well, no, let me see what it said. I did see something, Miss Holly. And it said, uh, system alerts. Currently been investigating security event to impact. What's JCAT server? That may not us. I don't know. May not be us.
That's how the PDs communicate with the inmates, like via email. That's my understanding.
Oh, that's what theirs is. Okay. Inconvenient. Okay, that's what I saw. I just saw service outage, but I didn't look to see what it was. Mhm.
Your Honor, I don't know whether or not you've received anything yet, but I sent it to both email addresses and also I faxed it.
All right, let's see what I got. I think I heard a ding. Hold on a second.
And if that be the case, the only thing we will be holding for is this interpreter case. And
Okay.
as soon as we get that done, I will send it.
Got it.
Wonderful, absolutely wonderful.
Do that now. So it looks like the email's okay.
You came out just in time, Mr. McLean. I was getting ready to send you a message, ask you how much longer it's gonna be.
Okay.
We're ready.
All right, where's the interpreter? Okay. Madam Interpreter, can you raise your right hand for me? You affirm that the interpretation that you will give from Spanish to English and English to Spanish will be correct and to the best of your abilities with no embellishments. Whatever I said. Oh, you're muted.
I do, Your Honor.
All right, thank you. All right. This is, hold on now. Put it to the side. Case number 24 CR 005832C.
Este es el caso. Este es el caso 24 CR 005832C.
And the case is Cindy Ramirez Portillo.
Es el caso en contra de Cindy Ramírez Portillo.
Charged with 2 counts of battery family violence.
Acusada de con dos cargos de violencia doméstica.
Okay. And I understand this is a first arrest.
Y de lo que yo entiendo es el primer arresto.
All right, State.
Your Honor, this incident happened on August 19th, 2024 at 1104 Caliber Creek Parkway in Roswell.
Este incidente, Su Señoría, ocurrió el 19 de agosto a las 11:04 en Roswell en Caliber Creek.
Officers responded to a domestic dispute that had just taken place. It was about 4:30 in the morning.
Los agentes de policía respondieron a una pelea doméstica que había ocurrido como a las 4:30 de la mañana.
There was an altercation over a cell phone and some text messages on that phone. According to the defendant, the victim struck her repeatedly in the face.
That was a mouthful.
Sorry.
That's okay. Hubo un altercado entre la víctima y la persona, y la víctima indica que ella le golpeó varias veces en la cara.
There were no injuries seen to the defendant.
No hubo ninguna lesión aparente en la en la persona.
The victim in this case is Cesar Gabriel Cervantes. He's the partner of the defendant, and he advised that the defendant began striking him when they were fighting over the phone.
La víctima en este caso es César Gabriel Cervantes, y él indica que fue la acusada la que empezó la pelea cuando empezaron a pelear por el teléfono.
The victim had scratches on him and a bite mark on his shoulder.
La víctima tenía rasguñones en él y una mordida, una señal de mordida en el hombro.
We have not been in touch with Mr. Cervantes today.
No hemos estado en comunicación el día de hoy con el señor Cervantes.
And this is her first arrest, Your Honor. The state's requesting an SOB through pretrial. No contact with the victim. Stay away from the residence. No drugs, alcohol, or weapons.
Y este es el primer arresto, y lo que la fiscalía está pidiendo es que no haya más contacto con la víctima, que salga de la residencia en la que viven juntos, la acusada, y una fianza.
All right.
Your Honor, all those conditions are fine with the defendant. She will leave. She will have no contact. She will stay away from the residence, which is occupied by her sister on the lease. Nonetheless, she will go elsewhere. She is in fear.
Okay.
Y Su Señoría, ella va a estar de acuerdo con esto. La acusada va a salir de la residencia, va a ir a vivir con otra hermana, aunque la hermana, una es la que está en el contrato, porque ella teme por su seguridad.
With a bit of luck, but not hopefully not actually relying upon luck, using the expression, Your Honor. With a little bit of effort and luck, I believe she can keep up with her court date through her sister and still maintain her safety.
Pensamos nosotros que ella puede mantener la fecha de la corte y puede estar segura por medio de la hermana.
Thank you.
Okay.
By the way, she has no children with him. She has 3 children of her own, but they are not here. And he has no children so far as she knows.
Y él no tiene hijos, de lo que ella sabe, y ella tiene 3 hijos, no aquí con ella, pero son 3 hijos que no son con él.
Okay. How long she been in Georgia?
I don't know, but with family here, I would imagine it's been substantial enough to know her way around. And by the way, she bakes bread, sells it by word of mouth. She cleans houses.
Y la juez pregunta que cuánto tiempo estuvo aquí. El abogado defensor indica que aunque no sabe, usted ya tiene su familia aquí, entonces lo más probable es que ha estado algún tiempo aquí y que usted hornea pan y limpia casa.
Can we get an answer on how long she's been in Georgia?
Sure. Madam Interpreter, can you ask her that directly?
Señora, ¿cuánto tiempo vive usted en el estado de Georgia? Señora.
You're muted, courtroom 2.
2 años.
¿Cuántos?
2 años.
2 years.
Okay. I'm going to order a $5,000 SOB through pretrial, 2,500 on each of the charges. Stay away from 1104 in Roswell.
Lo que yo voy a ordenar es un bono de fianza de $5,000 por medio de la oficina de servicios anteriores al juicio, y eso es 2,500 por cada uno de ellos. También la orden incluye no acercarse a la dirección de el 1104 Caliber Court.
And no, I'm sorry, I said to stay away from that address. No further contact with Caesar. I didn't get the last name.
Nada de contacto desde hoy en adelante, nada de contacto con el señor César Cervantes.
And no drugs, alcohol, weapons, or guns while on bond.
No drogas, ni alcohol, bebidas alcohólicas, ni armas mientras está bajo fianza.
And I think that's it. Anything else, counsel?
Nothing, Your Honor.
Oh, I'm sorry. With pretrial, then get a 1 week of anger awareness course.
That's what I was going to ask. Forgot to say that.
Y también necesita tomar una clase de 1 semana para manejar la ira.
What level?
Level 1.
A nivel número 1.
Is that it?
That's it, Your Honor.
Okay.
Thanks so much. My apologies, Your Honor, for defaulting on one or two. I had a limb fall on my house and had to get a workman out there and leave the house this morning.
Unless she has a question.
I think she have a question.
Oh. Yeah.
Sí, señora.
Oh, y para mis cosas que tengo ahí en el apartamento, ¿cómo le puedo hacer?
What can I do about my things that are at the apartment?
I give a one-time law enforcement escort to go back to retrieve her personal items.
Le van a dar una escolta una sola vez. Va a tener una escolta de un policía para que vaya a recogerlo sus cosas.
Gracias.
Thank you.
You're welcome. All right, that concludes this case. Did you get
Eso
those,
es todo en
Holly?
este caso.
I just received them and I'm getting ready to send you this last one.
Great.
Okay, wonderful.
All right, I think that's it. Miss Lucia, thank you so much.
Thank you, Your Honor. You have a good afternoon.
Okay. You too. All right, bye-bye.
Bye, everyone.
All right, bye, everybody else.
Bye-bye.
And
Bye.
McLean is ordering lunch and dinner for tomorrow.
I could try to do that. Let's see.